Good afternoon, everyone. Welcome to the Appellate Division First Department. Oral arguments for today, Tuesday, March 19. Let me start. We have a class visiting from Cardozo Law School. Yes, Professor Boglia? Bogia, how are you? So we welcome you and your students. I also have an intern here from St. John's. So we have individuals who are thinking about becoming lawyers, so therefore we are going to be on our best behavior and show them what it means to be a lawyer. Or maybe we'll just, what it should mean to be a lawyer. We'll try that. So I'm going to call the calendar now. You should all know by now that you should be requesting the time that you believe that you need in order to get out the salient points of your briefs, right? So we've read your briefs. We are fully familiar with your arguments, okay? So the time that in a perfect world, this is not a perfect world, we're talking about the time that you would need to get out the salient points of your arguments. People v. Eric Ramos. Submitted. People v. Johnny Rodriguez. Submitted. People v. Tyen Maiz. Oh, we were so close. 515. Woodley v. Poole. So that's 4, 2, 4, and 2. BFG 104 v. Greenwich Business. 6 and 6. You didn't want any time on rebuttal, sir? You did not want time on rebuttal? Okay, so you get 1. Muzi Inc. versus SK Iron State. That matter is submitted. GCA Advisors versus Intersections, Inc. Okay, so that's 625. Justice O'Neill Levy is recused on that matter. Cooper v. Monterey, 96. We have a respondent? Now, did you wish to submit? Okay, so I'll give you 2. People v. Ronnie Sanchez. That matter is submitted. David E. versus Michael E. That matter is submitted. Mana Amsterdam versus West 73rd. That matter is submitted. First case for argument is People v. Tyen Maiz. Yes, whenever you're ready.
Thank you, Judge. Elisa Gamliel for Appellant Tyen Maiz. This case is distinctly different from a mere failure to conduct a full factual allocution, because here, the aggravating element that enhanced the crime from a misdemeanor to a felony was hidden from appellant at all stages of the proceedings on the indictment. And it was this complete omission that triggered the court's duty to fully and accurately define the crime before Tyen Maiz.
So this was a bump up, right?
This was, yes, Judge.
So the initial information or the indictment is going to contain the statement that the defendant was previously convicted of a crime. Is that correct?
Well, the indictment, there was a special information that was appended to the indictment, but these are 2 separate documents. They are not part and parcel of the indictment. The special information is not part and parcel.
It refers to it.
It does, Your Honor, but it is not contained within the indictment.
There are two documents, but they are given to the defendant and his or her attorney.
Well, in this case, there's no record that that in fact happened. What happened in this case is that the special indictment was filed off calendar the special information was filed off calendar along with the indictment.
Is the
However,
defendant arraigned on that instrument?
the defendant was arraigned on the indictment, but when the people at Supreme Court arraignment, what the people handed over was a copy of the indictment. The people made no reference whatsoever to the special information.
Now, my understanding and my experience was always that when the defendant is arraigned on that instrument, he or she is also arraigned on the instrument stating that it's a bump up.
Well, certainly the court could have arraigned the defendant in this case on the special
All of this
information.
goes to knowledge. That's all I'm trying to
course.
establish or it's to determine is whether there's knowledge by the defendant that it's a bump up.
That's correct, Judge. And in this case, there was no knowledge.
No,
because
absolutely
here,
no knowledge it's a bump up.
there's no evidence in the record at all, Your Honor, that the special information was served on defense counsel or, and
Counsel,
certainly
I'm sorry to interrupt, but weren't there repeated references to his prior conviction on the record?
there were references to his prior conviction, Your Honor, but that happened in the context of the plea negotiation and specifically with respect to the judge's assessment of what an appropriate sentence would be.
In this particular case, with what he was charged with, what he pled guilty to, could it have been a felony without the underlying conviction?
Well, yes, Your Honor. There was a Class E felony, criminal possession of a firearm.
Was he charged with that?
He was charged with that, Judge. Yeah, so, and in fact,
But what was he pleading guilty to? Not the E, right?
no, he did not plead guilty to the E. He
And-
pled
and
guilty.
as far as his allocution, as far as him pleading, it was clear that he was pleading to a felony, correct?
Yes, Judge, and there's no claim here that he was unaware that he was pleading guilty to a felony. The claim is that he was unaware of the specific conduct that was required under the first count of the indictment, which was the bump-up felony, that he was never made aware of the
So now the special information is contained in the record, correct?
The special information is contained in the record, but again, Judge, these are two separate documents, and they're not always served together. I can tell you certainly from my own experience as trial counsel, they're often served separately. So the fact
Well,
that
often, but I see that, I noted this before at the arraignment, the criminal court arraignment, and also during the bail application, the people stated that defendant had been previously convicted of false personation.
Yes, Judge, and again, with respect to discussions of his prior record in the context of Supreme Court arraignment, that happened with respect to a bail proceeding. That was not with respect to the elements of the crime that he was actually charged with. And when we think about that, Your Honor, it's not reasonable for a defendant, and a layman, a non-lawyer, to understand that discussions of his record in the context of an appropriate sentence or whether or not bail should be set would have any relevance or be able to inform him of the requirement that there was a prior conviction element.
So I just also, is any of this preserved? Because I know we're talking about whether counsel was aware, whether counsel received, whether counsel imparted this information to his client, et cetera. Was any of this preserved, this argument?
Well, under People v. Worden, it didn't have to be. And People v.
Why
Worden,
not?
of course, because People v. Worden applies People v. Lopez. And in Worden, the court stated that where the court misdefines or erroneously defines an element of the crime and the
Oh, is that what we have here?
I believe so, Judge. Because what happened here is that the court, the crime was never fully defined at any stage of the proceedings for Mr. Maiz.
Is it that the crime wasn't defined, or is it that the court didn't allocute him as to the underlying conviction?
Well, it's both. And the fact of the matter is,
The failure to allocute on all elements, that's not fatal, is it?
in the ordinary case, it may not be. However, in this case, because there was never a full definition of the crime given to the defendant, the court had an
What do
obligation
you mean by
to
full
fully-
definition? He didn't know that he had been previously convicted of false personation?
Your Honor, what he was unaware of and what neither the court nor the prosecution ever made him aware of was the fact that this crime hinged on a prior offense. Without that prior offense, the people had to prove the prior offense in order for him to be convicted of this crime. And that is the point. That is what he was never made
He
aware
pled
of.
guilty to criminal possession of a weapon in the
Third degree.
third degree.
Correct.
During the allocution, he was allocated as to criminal possession of a weapon in the third degree. Did he express any confusion as to what that meant, meaning pleading guilty to criminal possession of a weapon in the third degree? Did he express any confusion as to whether that was a misdemeanor or whether that was a felony?
Well, Judge, the claim here is not that he was unaware of whether or not he was pleading guilty to a felony versus a misdemeanor. And he would not have had reason to express confusion because what was read out
The
was
claim here was that he was not made aware of an element. Your claim is that he was not made aware of an element of a crime.
correct.
Right. So my question is then, under Lopez, does that state that the allocution that the defendant has to be made of every element of the crime? And I thought that Lopez said no.
Under Worden, Lopez does not state that, but under Worden, and Lopez is consistent with this, where there is a misdefinition, where the court
Right. And
erroneously
we're back to
defines the crime.
misdefinition.
And what happened here, Your Honor, if I may, is that the failure to include this element where, because in this case it had been excluded at every stage of the proceedings, Mr. Maiz had no reason to know of its
And
existence.
see, that's where I question your argument, because that's where I'm not. You are somehow stating that the failure to specifically state the element as to the underlying conviction, that somehow becomes a misstatement as to the crime.
And the reason that it did, Your Honor, is because what happened here, in effect, was that Mr. Maiz was allocated on the elements of a misdemeanor while being convicted of a felony. And he had, of course, a right to know. He needed to know
Well, that's
what
why I
the
asked you
specific-
whether there was any confusion as to whether he was pleading guilty to a misdemeanor or a felony.
But these are sort of two distinct concepts, right? The question is whether or not...
Because my understanding is that he intended to, and it was his purpose to plead guilty to a felony.
Right.
In order for him to make a reasoned choice amongst the alternative courses of action that were before him, he had to have understood, just fundamentally, he had to have understood the critical elements of the crime. And because that was never specified...
And I think we have to sort of take that he had appropriate discussions with his attorney.
Well, Your Honor, we can't assume that in this case.
No, we
In
can't, but we
fact-
don't have the 440, so we won't know. But you have time on rebuttal.
Thank you, Judge.
Good afternoon, and may it please the court. Peter Rienzi on behalf of the people.
Counsel, was the defendant arraigned on the special information?
Your Honor, it is not clear from the record that defendant was specifically arraigned on the special
If he was
information.
not, is that fatal?
No, Your Honor, it isn't. It's not because, first of all, it appears from the record, every reasonable inference from the record, it appears that the special information was part of the indictment. In the judgment roll, the appellate division record, it is literally within the pages of the between the pages of the felony charges and the back of the indictment. In addition, as Your Honor pointed out, it wouldn't be the D felony that he pleaded guilty to would not be a D felony if that special information had not been filed with the court.
And when he's being allocated, the judge said, I understand from your attorney you wish to plead guilty to count 1 of the indictment to the D felony, criminal possession of a weapon in the 3rd degree, in violation of penal law section 265.02, subsection 1.
Yes, Your Honor. Yes, it was noted many times that it was the first count of the indictment, it was a D felony, and the penal law subsection, all of that was made very clear to the defendant. And
Counsel,
Yes.
if I may,
Yes.
counsel repeatedly refers to Warden, People v. Warden.
Yes.
Now, in that case, though, there was some type of misunderstanding of the law in that case, and also an element of the charge was negated. Did that happen here in this case?
It did not, Your Honor. In Worden and Johnson, the cases that were cited at length in defendant's brief, in both those cases, during the allocutions, the defendants in those cases pleaded in a way that was inconsistent with the elements of the crime. Nothing of the kind occurred in this case. The element that was discussed, which was the possession of the firearm, was admitted to properly, and then there was no allocution about the prior conviction, although, as one of Your Honors mentioned, that had been raised. It was not mentioned during the allocution, though it was raised during that court appearance, and and it is a fact that no one is disputing that defendant did have the prior conviction.
Was there any
yes.
indication that he didn't understand this allocution of the gun possession?
I believe there was no indication of that, Your Honor. I think that, again, it was mentioned several times on the record that it was a D felony. It was a lot of the conversations that occurred during the plea, including whether or not he was a predicate felon, the different disposition that the counsel asked for, even less jail time than the defendant received, all those things that were discussed during the plea colloquy assume that that it was a felony he was pleading to, and most of all, the fact that this was a one-time offer from the court. The one-time offer was 1 city year, 1 year in jail, and obviously that is not a particularly attractive one-time offer if we're talking about an A misdemeanor. That's a one-time offer that was immediately accepted, and the reasons for the offer and the acceptance, it makes the most sense. The most reasonable inference is that this was in the context of somebody facing far more time.
But we don't have to speculate because he was told repeatedly that he was pleading guilty to a D felony under the first count of the indictment.
That is correct, Your Honor.
At least twice.
Yes, Your Honor. In addition, as was raised earlier, none of these arguments were preserved, and they do not fit within the exception that Lopez lays out. Lopez itself made clear, as Your Honors are aware, that the plea court's duty to inquire further is not triggered merely by the failure to recite every element, and that is what occurred here. And again, none of what happened here triggered the court's duty to inquire further, as no elements were negated. If there are any further questions, I'd be happy to address them. Otherwise, I will rest on our brief.
Thank you so much.
Thank you.
The reason that Lopez does not require a specific factual allocution on every element of the crime is because in the ordinary case, when we're dealing with a crime that does not rest on a prior offense, the indictment itself specifies each and every element. And so the court can be assured in that scenario, the defendant is aware of the nature of the offense. When you have a scenario like this, where the indictment itself omits the critical element, the single element that raises the grade of the offense from a misdemeanor to a felony, we can no longer rely on the indictment to provide that sort of notice.
Where's the confusion if the defendant is told at least twice that he's pleading guilty to a D felony?
It is not, the question is not whether or not Mr. Maiz understood that he was pleading guilty to a felony, and that is not the claim here. The issue is whether or not he understood the critical elements of the crime and was able to, was able to make a decision to refute them or to accept them or to
But
plead
don't the
guilty to
cases
them.
also state that a defendant does not have to be told of each and every element of the crime charged?
As long as he is provided notice in the indictment and is aware, I mean, at the end of the day, for a plea to be voluntary, the defendant has to be aware of the nature of the offense. And when an element of the crime is hidden at every stage of the proceedings, there is no possible way that the defendant can be aware of the nature of the offense. And that's why here, Your Honor, the fact that there were repeated references to him pleading guilty to a D felony is really of very little significance, because what was critical was that he understood the nature of that felony as an enhanced crime. And that's what was missing from every stage of this proceeding. He was never arraigned on the special information, and he was never given notice of it. And with respect, and this is the last
Well,
point.
no, you're finished, but thank you. Thank you both.
Thank you.
Woodley v. Poole. Yes, whenever you're ready.
Thank you. Good afternoon, and may it please the court. My name is Ava Celia, and I'm an attorney with the Brooklyn Defenders Family Defense Practice for Miss Margot Woodley. Your Honor should reverse the decision of the lower court because the plain language of the relevant social services law, in effect at the time of Miss
Counsel, I was
Woodley's...
taking a look at another case that was decided June 28th, 2022, and that was Jeter v. Sheila Poole. And from my reading of this case, I thought it was on point. And the facts and the decision by this court seem to be almost the same as here in terms of the facts. So why would this not control?
The two cases are clearly distinguishable. Unlike Jeter, Ms. Woodley is not arguing that the amendment should be applied retroactively. Rather, she is arguing that they should be applied in accordance with the plain language of the statute.
Right, so in that case, we said, unless the language expressly or by necessary implication requires retroactivity, there is no retroactivity.
Again, we are not arguing that the amendment should be applied retroactively. We are arguing that they should be applied in accordance with the plain language of the statute. And that plain language provides that, quote, there shall be an irrebuttable presumption in a fair hearing held pursuant to this subdivision.
And
End
that
quote.
applies to pending administrative proceedings. That's the implication of your argument, correct?
No, that applies to fair hearings at the fair hearing stage.
So when was the fair hearing here?
Pardon me?
When was the fair hearing? When did that take place here?
Ms. Woodley's fair hearing was on February 8th and March 3rd of 2022. So after the January 1st, 2022 amendments effective dates. So at that time,
That fair hearing is part of an appeals process, correct?
correct,
It
but
doesn't
there are
happen in a
two,
vacuum.
correct, but there are two distinct and unique stages to that appeals process. The first stage is this administrative review process, and that is governed by its own subsection. The second phase is the fair hearing stage.
The first
and that is
phase happened
governed-
before the amendments were passed, or were effective, rather, correct?
That is correct. And again, the plain language of the statute that was in effect at the time of Ms. Woodley's hearing provided that the irrebuttable presumption be applied in the fair hearing stage, and her fair hearing was held after the January 1st, 2022 amendments effective dates.
If we find that the statute is ambiguous on this point that we're talking about, does that mean we have to defer to OCFS? In other words, they, being the administrative body, they're entitled to interpret their organic statutes in a way that we give them deference.
So again, it is our position that the plain language of the statute is not ambiguous.
Right. But I'm saying if we find that it's ambiguous.
Sure. So, no, because there is no specialized knowledge or expertise necessary to interpret this statute. And again, the plain language should be applied, which would require the irrebuttable presumption to be applied to all fair hearings held on or after January
So the
1st,
statute,
2022.
the legislature did give OCFS the ability to promulgate any rule or regulation necessary for the implementation of it. So again, why would we find that this rule is, would we have to determine that it was ambiguous or it was contrary to the intent of the statute?
Again, the plain language of the statute that was passed by the legislature provides that the irrebuttable presumption must be applied in all fair hearings held after January 1st, 2022. The analysis should stop there because the language of the statute is clear and has a rational meaning on its face.
Thank you.
Good afternoon, Elizabeth Brody for Respondent, OCFS. The plain language of the statute does not say that it should be applied in any fair hearing held after January 1st,
Is there
2022.
any special knowledge or experience or something that it's needed on your behalf or that you possess to interpret that statute?
Yes, there is, and that's the complexities and interdependencies associated with the administrative review procedure. So the
What do you
amendments...
say to your adversary's argument that on its face the statute says that it applies to fair hearings?
It does say that on its face, but OCFS has the better and more rational reading of the statute here in order to cohere all of the statutory amendments as a whole, because this is only one piece of it. It has to be that the irrebuttable presumptions are applied at the earliest stage. This type of irrebuttable presumption, for example, when a family court makes a finding that the abuse or neglect did not occur or dismisses pursuant to an ACD, obviates the need for a fair hearing altogether. That's in the statute.
So
And
the,
so it
the
would-
way that the agency interpreted the statute, its goal, or one of its goals, was to avoid administrative havoc. Is that right?
That's correct. So the amendments recognize that OCFS does not have direct access to family court records or to the family court computer system. Accordingly, the amendments direct OCFS to, at the earliest stage, as soon as they receive a request for an appeal, to solicit information about related family court proceedings from the 58 local child protective services around the state. And when there's a pending family court proceeding, the same amendments that added this new irrebuttable presumption direct OCFS to pause its review. And that's because, and then direct OCFS to apply these irrebuttable presumptions based on the outcome of the family court proceedings. And so the new processes in the amendments can narrow the issues at a fair hearing substantially, or indeed obviate the need for a fair hearing altogether. The legislature could not have intended OCFS to wait until the fair hearing itself to apply an irrebuttable presumption that obviates the need for the fair hearing completely. And I would encourage this court, in construing the sort of structural ambiguity around these provisions in the statute, to look at Long v. Adirondack Park Agency, 76 New York 2nd 416, which is in our brief. There, despite arguably clear legislative language about when the Adirondack Park Agency could overturn decisions of local zoning boards, the court held, nevertheless, that to effect the purpose of the statute, they would have to extend the review period from the 30 days specified in the statute from when the zoning board decision took effect to 30 days after the Adirondack Park Agency received the necessary information to conduct its review. So I would say that that case is squarely on point. If there are no further questions, we urge this court to confirm.
Thank you.
Good afternoon, and may it please the court, Rebecca Viscatas for the Administration for Children's Services. While ACS agrees with OCFS on the merits of this case, really I briefly just want to make sure that the court addresses ACS's position that it's not a necessary or proper party in this case or others like it. This is something that ACS regularly raises at the trial level, but it often goes unaddressed in court's opinions, as it did here. And we anticipate that if this court does make clear that the petition should be dismissed against ACS and that ACS is not a necessary or proper party in Article 78 proceedings challenging a state administrative hearing, that will be helpful in preserving both agency and judicial resources. The petitioner in her reply brief said that she does not oppose dismissing the petition as to ACS. So this is really an undisputed issue in this case, and we believe that an opinion from this court reflecting that will be helpful in additional cases in this vein. As to the merits, while there is no relief that can be granted against ACS, we do agree with OCFS's legal position, and we stand by the results of the ACS investigation here. I'm happy to answer any questions about that, but otherwise we will rest on our brief. Thank you.
Thank you.
Thank you. So OCFS's interpretation, regardless of how reasonable it may or may not be, does not comport with the plain language of the statute and therefore should not be given any deference. The relevant social...
Why?
Pardon me?
You said it shouldn't be given any deference, and usually an
Should not be
agency-
given any deference.
Right, so I'm saying why, because usually that's the case.
Because the plain language of the statute has a clear and rational meaning, which requires the irrebuttable presumption to be applied in all fair hearings held on or after January 1st, 2022. And the social services law simply requires that the presumption be applied in a fair hearing, not that it only be applied in the fair hearing stage, or that it not be applied at the administrative review stage. So,
Is there any evidence in the legislature's intent that this would be applied retroactively?
again, we are not arguing that it should be applied retroactively. We are simply arguing that it should be applied in accordance with the plain language of the statute, which requires the irrebuttable presumption to be applied in the fair hearing stage. And Ms. Woodley's fair hearing was held after the amendment's January 1st, 2022 effective dates. If OCFS wants to apply the irrebuttable presumption at the earlier stage, there is nothing in the social services law preventing them or forbidding them from doing so. The social services law simply requires that it be applied at the fair hearing stage. OCFS is free to apply it beforehand, but what OCFS is not free to do is to not apply the irrebuttable presumption at all and force Ms. Woodley to a contested hearing on allegations that had previously and already been dismissed by the family court.
Counsel, I just want to go back. What's so irrational or unreasonable about the interpretation that you're challenging? What's so unreasonable about that or irrational about that?
Again, I don't think that the question is whether or not OCFS's interpretation is rational. The issue is that it does not comport with the plain language of the statute, and the analysis should end there.
Thank you. Thank you all.
Thank you.
BFG 104 versus Greenwich Business.
Good afternoon, Your Honor. Jacob Neiman from Carter Ledyard and Milburn on behalf of the appellants. In order to get a preliminary injunction, the applicant needs to show clear right to the relief sought, and they need to show clear and convincing evidence. In the application below, the preliminary injunction alleged that plaintiff was actually able to successfully enforce the master funding agreement and tri-party agreement and directed all of the receivables from the ACH collections to itself by May 1st, 2023. In other words, they were paid in full, and they continued to be paid in full at the time they went in for the preliminary injunction application. They have not demonstrated.
Justice Maisley counsel amended her order right in early this year, January 12, 24, and she specified the RTRs that are available to the plaintiff, correct?
She said that it was the ones on the 61 purchase and sale agreements.
Right. So does that moot out that part of your argument that it was overreaching in the first place? The preliminary injunction?
To the extent we asked this court to identify which merchants should be included, that is mooted out, yes. But the court below had abused its discretion in granting the preliminary injunction on 5 different grounds. First, granting ultimate relief. Justice Masley granted the ultimate relief of control over the entire merchant portfolio. That was the ultimate relief sought in the addendum clause to the complaint. It gives complete control to the plaintiff without them having to actually prove their case.
Counsel, I just want to be clear. You're now raising the issue of whether that plaintiff cannot succeed on the merits?
Yes. Well, this is the ultimate relief prong, but they have not.
Did you raise that below?
Prior counsel did not raise that particular issue below, but that's an issue of law that is preserved on the record. It's on the face of the complaint whether the plaintiff had actually demonstrated a breach of contract in that they've had the full receivable portfolio diverted to them.
I mean, the complaint alleges a lot of things that you're not doing that you're supposed to do under the various agreements. So that, their read-only access is not being provided. That's something that was provided in one of the agreements. Also, and this is, I'm sort of pivoting here, does Rosier sort of give away the store on all of this?
I'm sorry, gave away?
The store. I'm using colloquial expression to say that she admitted fraud or at least breach of contract.
She never admitted to committing fraud. What was admitted in her affidavit was that there was a discrepancy with regard to some of the merchants that were sold to the plaintiff.
Discrepancy, or that they were fictitious?
Right. I thought that's what she said.
She said that there were some that were not real.
Right. That's fictitious. That's beyond. Yeah.
Again, I'm not parsing her words. I'm just saying that she has made that admission. She was fired. She was removed from the company. By May 1st, every remedy available under the master funding agreement was fulfilled. They were able to take full control of the ACH portfolio. They were able to contact merchants and ask the merchants to divert their funding. They were paid in full as of that date. So there's no breach of contract that was alleged after that date. They have no remedy. They have no damages after that period. Regardless of what happened before, by May 1st, everything was resolved in their favor. There was no reason and no basis to grant a preliminary injunction, let alone one that grants the ultimate relief sought in the complaint. And what was raised in particular down below was the lack of irreparable harm. This is simply a money damages case. As Justice
Going out of business, going bankrupt, isn't that an irreparable harm?
for the plaintiff to go bankrupt,
Yes.
they were not going bankrupt. They've only made conclusory allegations of bankruptcy. In fact, their website till this day says that they're they can fund $100 million portfolios. Conclusory allegations of irreparable harm are insufficient. And as your honors know, irreparable harm is the most important point on an application for preliminary injunction. They've not demonstrated that. They simply said that there were creditors. They've not identified a creditor or said what the debt was or why it's not being paid. But more importantly, this is a money damages case on a commercial investment. And in this court just held a month and a half ago that in such a case, money damages are adequate and there's no irreparable harm, and that was not demonstrated here.
Well, the Levy affidavit stated that they would likely to default on its obligations. That's not.
That was the definition of a conclusory allegation. He didn't identify who those creditors were. He didn't identify the amount of that of those supposed obligations. He just said it. There's no information there, and to this day they're still functioning. So the irreparable harm was conclusory at best. If there's no further questions, I'll rest on the brief.
Thank you. So if you could address the irreparable harm argument, but also your adversary states that everything was resolved by May 1.
Yes, Your Honor. Absolutely, everything was not resolved by May 1. By May 1, at that point, we were just notified that there was a massive fraud committed against us. We had 61 purchase and sale agreements that we signed with Greenwich Business Capital. We had performance guarantees with Mr. Rogier and Mr. Ponte, and we learned at that time that many of the receivables that we purchased were using Mr. Rogier's words, which the court picked up, were fictitious. And the court, on this issue, the court said specifically that the client's employee committed fraud, and she admitted it, and that's the affidavit that she put before the court. And that, by the way, was not submitted by Mr. Rogier's. That was submitted by Greenwich Business Capital and Mr. Ponte. At that time in the case, Mr. Rogier's did not answer, despite the fact that she was a defendant. And so at May 1st, absolutely, we were not being paid. The money that was coming in from the merchants that were actually real, that money was not being given to us. It was going into the segregated account, which, picking up on Your Honor's issue, we did not have access to at that point because Mr. Ponte restricted access. And then at the lower court, Greenwich argued that the status quo should be May 9th, when the ACH company that was used at that time was holding the money in escrow because Mr. Ponte had said on May 2nd, no, that was not my signature on the tri-party agreement. The court looked at this issue specifically and rejected defendant's argument at that point that the status quo was May 9th and said the status quo was May 3rd, when the ACH company looked at the agreements at issue, the funding agreements, master funding agreement, tri-party agreement, and said under these agreements, we have to allow the money to go to BFG. It is their contractual right. So the court very much looked at this issue and said the status quo is May 3rd, because before that we were not getting paid. And now the defendants are saying the status quo should actually be April 26th, a new argument that was not raised below. But April 26th was when BFG was being defrauded, and BFG had no idea about it. And Greenwich and Mr. Ponte had control over those funds. So that was not the status quo.
I'm sorry to interrupt you. What further relief are you going to seek? In other words, he's saying this is the ultimate relief, and you've got it. What else do you want?
Well, it absolutely is not the ultimate relief, because this doesn't require that merchants pay. Merchants are, and this is the subject of 2 contempt motions and an order of attachment that's below with Judge Maiz, because we are not getting money. The merchants are not paying, given the contempt that Mr. Ponte and Greenwich are doing. And so the ultimate relief is our full recovery. We have performance guarantees that require that Mr. Ponte and Mr. Rogier's, and in the funding agreements that the MCA, when they default, which absolutely a admitted fraud is a default under these agreements. When they default, the MCA has to cover any deficit, and if the MCA doesn't have it, then that's why we have performance guarantees. And so our ultimate relief will be recovering all of the money, but we do not have that right now. Merchants, this doesn't require, again, that merchants pay us. It requires that Mr. Ponte and Greenwich not wrongfully divert the money, whatever money is there from the merchants, to us. So that is not the ultimate relief, and we certainly are not receiving the ultimate relief right now. And to Your Honor's point on irreparable harm, we did put in Mr. Levy's affidavit that without collections coming in, the business would go out of business, wouldn't survive 2 years, and we show the cases that is sufficient.
Well, your adversary stated that the statements were conclusory and that there was no proof in terms of which creditors would not be, who would not be paying, et cetera.
Thank you, Your Honor. Well, again, that argument was not raised below at all, but and so again, it's a new argument, new counsel's coming in making new arguments, but Mr. Levy's affidavit and his reply affidavit do support that. I mean, yes, we didn't put in the underlying lender agreements, but absolutely, without the funds, there would have been a default. And
well, so therefore, is there any substance to the argument that, or significance to the argument that you are still afloat? You have not declared bankruptcy?
Well, we haven't declared bankruptcy, but I'm not sure that I would still agree if the record would be open that we are still afloat. We were in default under the loans, and that's part of what's under contempt too, that we are not receiving the funds. Right now, we've only received around $2 million of the, outstanding. Our debt is around $10 million because of the Greenwich and Mr. Ponte's wrongful diversion of the funds, despite the fact that the injunction is in place. And that, Your Honor, Judge Maiz looked at this issue, and she did have concerns about irreparable harm, but she looked greatly at our evidence, the fact that under the Garden City case that she relies on, where you have a systematic fraud that was, and in this case admitted, and in Garden City admitted as well. You have a systematic fraud. You have, by an employee there, DeRosa's, which also the record shows that even after she was, quote unquote, fired, not only did Greenwich and Mr. Ponte submit her affidavit, but they also, there's emails in the record that she was still acting on their behalf at that time. So not only is the systematic fraud found, but then again, in the lower court, there's no dispute about likelihood of success. There was no dispute about balance of the equities at all. And there was no harm that defendants at the lower court said that they would even receive if this injunction were in place, where we had a systematic fraud and we said that we would go out of business without receiving the funds.
And does the contract provide that you can seek this remedy? Is that part of the contract if you aren't being paid?
Absolutely. The contract says that when there is a default, there are several remedies that we have available. One of them is to alert the ACH company, and here it was Vericheck, to divert basically take the MCA out of it, Greenwich, divert any incoming collections from merchants on purchase RTR to us. The Greenwich is also supposed to instruct any merchants to pay us directly. And then we also have the performance guarantees where if there's any deficit, which there is likely a deficit here because receivables that we purchased and advanced money on, which Mr. Roja has admitted, never existed. And so that RTR we cannot go collect from. So yes, the agreements give us this right, absolutely, and that's what, again, was undisputed by counsel. I think counsel said he does not dispute, at the lower court, did not dispute that the contracts say exactly what occurred here.
Thank you.
Thank you.
Just on that last point, the contracts provide no deficit provision. This is a purchase of receivables. So if there's no receivables that exist, there can be no deficit on that the defendants would have to make up. Another issue.
So you're talking about the fraud.
So fraud, you only get out of pocket damages. When I say deficit, I mean if merchants on these 61 purchase and sale agreements did not pay, they don't deliver their receivables, they collect nothing. That's the rule. But in any case, they diverted everything by.
What do you mean that's the rule?
This is a purchase of receivables, not a loan. There's no absolute payment obligation under Section 2 of the master funding agreement. If there was a absolute payment obligation, there'd be other issues, but this is supposed to be a purchase of receivables. That means only if receivables are generated by the customer then they would have to be paid over. If $0 in receivables come in because there's a failure by any of these underlying merchants, because they go out of business, because they refuse to pay, because they're confused about where payment goes, there's no collections, and there's certainly no deficit that would be payable over under a guarantee.
Thank you, thank you. GCA Advisors versus Intersections, Inc. Justice O'Neill Levy is recused on this matter.
Your Honors, may it please the Court, Erica Aiken on behalf of Appellate Intersections. This appeal raises a very narrow question. Did the parties agree that Intersections would pay a $1.25 million transaction fee to GCA for a transaction GCA had no involvement in bringing about? The answer to that question is quite simply no. This court should reverse the ruling of the Supreme Court and enter judgment in favor of Intersections for three primary reasons. First, the plain language of the contract requires reversal. The language of the contract makes clear, Your Honors, that GCA was required to perform some work in order to receive 1.2.
Okay, so where in the agreement does it state that plaintiff is to perform any post-termination services in order to be entitled to the transaction fee?
Your Honor, I think the plain language on page 2 of the agreement under the compensation provision, which lays out exactly how GCA would be compensated, says that the fees payable to GCA, quote, for the foregoing services shall be an advisory fee of $100,000 and then the transaction fee that is at issue. If Your Honor looks to the prior paragraph for the foregoing services that's on page 1, it says quite plainly that during the term of our engagement, we will provide you with financial advice and assistance in connection with the transaction. The preamble repeats that same in connection with the transaction language. The contract read as a whole.
Demand was made after the engagement ended.
Yes, Your Honor.
And under the tail provision. So how can you rely on the language that you're referring to when the demand was made under the tail provision and the engagement ended?
Well, Your Honor, the tail provision should not be read in isolation, as this court has made clear in cases
You're all
such
a
as
sophisticated parties, right? I mean, the tail provision doesn't tie in any performance.
The tail provision simply says if during the term of this agreement or any time within 12 months after the effective date of termination of this agreement, a transaction is consummated or agreement is entered into with respect to such transaction, et cetera, a transaction fee as defined below will be paid.
Well, Your Honor, you just read prong B of a two-part prong, and the preamble to that says for the foregoing services. So that's baked in quite clearly into 2B of the transaction fee, says that these will be paid for the foregoing services. And for that reason, you have to look to the contract as a whole. As this court has said, it's a cardinal principle of contract interpretation to look at the agreement as a whole.
That's true, counsel, but does your interpretation render the tail essentially meaningless and unnecessary?
No, Your Honor. The tail provision is not rendered meaningless simply because it has a meaning that is different from what GCA would like the court to believe. GCA's position is that it doesn't have to perform any work in order to receive the transaction fee. If you look at the context of the agreement in that same section under the transaction fee, it shows that can't be true. Under the agreement, GCA was to receive a $500,000 transaction fee if the company sold to Loeb. Loeb was already on the table. GCA was going to perform an analysis of that and determine whether or
They had a much higher fee if it sold to someone else.
That's correct. Over double the fee, Your Honor, a $1.25 million fee.
And that's what happened here. It sold to someone else.
That's exactly what happened here. And the intent of the parties, Your Honor, though, could not have been for GCA to receive over double the compensation for a transaction for which it did no work.
So you make the point in your brief that that additional fee or that larger fee reflects that they had to do extra work for a non-Loeb transaction, and that therefore that supports your theory, correct?
Yes, Your Honor, and we believe that the cases in this court make that quite clear. If you look at the Storm Harbor case, which was cited by our opponent, that case involved a contract where Storm Harbor decided that they were going to collect under the tail provision of the contract. There, the parties said, hey, well, we don't think you did any work under the tail provision of the contract, so you shouldn't get paid. This court said, well, in this case, Moelis actually engaged the person, New Residential, who ultimately made the purchase. And because of that engagement, Moelis was entitled to the fee. It's quite clear, Your Honor, that this court has said on multiple occasions that the tail provision should not be used as a sword. Instead, it's used as a shield to protect people who actually did work, but the transaction just did not culminate until after the contract closes. It is not meant to be used as a method of achieving greater or double fees. In
If
a
your
situation
intent
where
was
you
that the
did
tail
more work.
provision would only apply to instances where they performed specific functions or work, you could have said that.
And we did, Your Honor. We said that in our briefs below. We said that.
No, you could have said it in the contract.
We believe it's reflected in the contract.
In a roundabout way, if one was to follow your argument, but you could have said that very straightforward in the tail provision, correct? Where there is no ambiguity as to what was required.
Yes, Your Honor, but this court has actually said the opposite when it comes to interpreting contracts. In order to interpret
The first thing about the contract is the plain language, right? What does it say?
Yes, and interpreting the plain language of the contract, Your Honor, should not be interpreted to result in an absurd or unreasonable result. This court has expressly said that absent an express provision calling for that harsh or that absurd result, this court should not interpret the contract in that way. And that's precisely what we argued below, and that's what we argue here. If you're going to be looking at the contract in order to figure out whether or not it's ambiguous or the plain meaning requires some type of work, the reasonable, rational, and economic sense conclusion is that some work was required in order for GCA to get paid double the amount that it would have been paid had it closed that transaction with Loeb. That is simply undisputed here. Additionally, Your Honor, if you believe that the contract is ambiguous, let's assume, for example, that both
Yes,
parties...
we'll deal with that on rebuttal. Thank you.
Yes, Your Honor.
May it please the court, my name is Jeffrey Little, and I
So
represent...
counsel, you know, there's an interesting argument by your adversary. In that section, it says the fees payable to GCA for the foregoing services shall be paid in cash via wire transfer and shall be as follows. Then you have advisory fee, and it talks about the advisory fee. Then it has transaction fee. So why would we not read advisory fee and transaction fee as only being for the foregoing services?
Well, the reference to foregoing services, I presume, is a reference to paragraph or section 1 of the agreement on page 1, and you can see that each and every one of the services is modified by services that may include the following. There's no mandatory service here, and there's absolutely nothing in this contract that requires GCA to actually be a finder of the acquirer. And I think that was very clear below, but the advisory fee is some sort of retainer, so to speak, and the transaction fee is after services were performed. There's been a huge misinterpretation, I think you can see in Mr. Blady's affidavit, paragraphs 9 and 10, that there was a tremendous amount of work that was performed. And that gets us to, I do believe,
That was tremendous amount of work was done with respect to the Loeb transaction only, correct?
Pardon?
That tremendous amount of work, it was only done with respect to the Loeb transaction?
No. As I believe Mr. Blady's affidavit states, there was a list of something on the order of 50 companies that the GCA contacted. You'll notice in that list of services in the first paragraph of section 1 that Loeb isn't actually even mentioned with regard to the services. In fact, it's excluded in a parenthetical. So,
So isn't a $1.25 million fee for a $100 transaction commercially unreasonable?
it's, I mean, I know that it's stated that way, but both the judge below, Judge Maisley, and dealt with this issue, and you've dealt with this issue. This court has dealt with this issue in the Moelis case, and in Storm Harbor. This is a tail fee. This is what the issue is here. A tail fee exists for a variety of reasons. I don't think I need to elaborate what they are. But GCA did everything that was necessary to earn the tail fee. Now, if you read very carefully the brief, which I know you have from Intersections, what you'll see is that they now say GCA should not get this fee because it did nothing with regard to the One Health transaction. The problem with that is that GCA was terminated, and at that point the tail fee time period starts to run. And after that, One Health was created. And one of the insiders, as Justice Maisley pointed out, who was involved with the Loeb transaction, one of those insiders was the primary shareholder of that company, and they did the transaction thereafter. And this is very similar to the Mola situation, where the court directly addressed that issue. Do you have the entitlement to a tail fee if you did not perform the work necessary to culminate the transaction? And the answer was yes, so long as the rest of the agreement is, as Judge Maisley said, really clear, abundantly clear.
I think what my colleague was getting to is the fact that we're talking about 1-something million for property that's only worth $100.
Well, I
think that's what the issue is. That not to some extent unconscionable.
I don't think that the property was only worth $100, but I don't think that was an issue that this contract required there to be any kind of interpretation of. GCA was approached by the company to do this business. And the disproportionality between saying it's $100, not mentioning that that there was a $20 million debt forgiveness in addition that was given to One Healthcare in the process. I think that indicates that it was a lot different transaction. And
Thank
without,
you.
Very briefly, Your Honor, GCA does not dispute that it did not do any work in connection with the One Health transaction. That alone is enough for reversal because work was required to be done in connection with the ultimate transaction. Your Honor is correct that the $1.25 million fee for a $100 transaction would be absurd and commercially unreasonable. That $100 determination is a binding decision of the arbitrator on this court. Additionally, Your Honor, if the contract is ambiguous, the parole evidence makes abundantly clear that GCA was required to do some work in connection with the One Health deal. Internal emails that were presented to the lower court from GCA's own director state, we have to bring in another buyer in order to get the higher fee multiple times. Mr. Blody, who opposing counsel quoted from today in his deposition, said everybody understood that after the Loeb deal fell through, the work was done. The parties were not acting as a contract was still in place. There was no contract still in place. In fact, the special committee that had retained GCA disbanded, so there was no client for them to even work with. Your Honors, he mentioned the Molis case as well, but the Molis case did not address this issue because in Molis—
It did. I'm looking at it. It is irrelevant. Molis did not work on the 2017 disputed sale transaction because it occurred during the tail period and involved new residential. So in that case, this court indicated that although the organization did not work on the transaction, they were entitled to the fee. It happened during the tail period.
Well, Your Honor, the operative words there that you just read were "and involve new residential." And when you read the case as a whole, the case quite clearly states that that party had engaged new residential on behalf of the person. Right. Again, that's exactly how the tail provision works.
Right, I did read it. Yeah, I did read it, and it doesn't include that language that you're required to work on the transaction. But
Your Honor, I think read in the context of the opinion and new residential and involved new residential means that it involved someone that GCA had, that the party in that case had actually contacted and engaged for the parties.
Thank you. Thank you all. Cooper v. Monterey 96.
Good afternoon, Your
I'm
Honors.
just going
and
to
may-
wait for Justice O'Neill Levy to return. Okay, you may proceed.
Thank you. Good afternoon, Your Honors. It may please the court. Ross Frischer for defendants, appellants in this matter. The motion court erred in granting plaintiff's motion for summary judgment for two main reasons. First, plaintiff did not meet his prima facie burden in showing that plaintiff had the legal right to occupy the subject apartment, either as a sublessee or otherwise. And defendants raised tribal issues of fact demonstrating that plaintiff had no legal right to occupy the subject apartment. As such, no cause of action under RPAPL 853 could be maintained here. Plaintiff did not meet his prima facie burden because the only evidence submitted with his moving papers was his self-serving conclusory affidavit. Plaintiff did not submit the purported 29-day invalid sublease, nor did he allege that the purported sublease was authorized by the defendant landlord. Therefore, plaintiff did not meet his burden in showing that he was a lawful occupant of the apartment. Defendant landlords raised tribal issues of fact regarding defendant's legal right.
Did plaintiff establish that he was an occupant of the apartment?
I don't believe so, Your Honor, because he did not annex the lease, although he said in his affidavit that he was, and that he was a subtenant. There is no other proof annexed to those moving papers. So that's a self-serving conclusory
Well, did he
affidavit.
not demonstrate that the landlord went in and removed his property from the apartment?
It alleged that he changed the locks. That affidavit, and that affidavit refers to the 29-day sublease, which you can see on page 19 of the record. So in the event that he alleges that it was prior to the expiration of the sublease that he was evicted or removed from the premises, you can look at page 19. That purported sublease provides that he had to vacate the premises no later than August 28th, and this was August 29th that plaintiff changed the locks. In fact, because defendant realized that the plaintiff had changed the locks the day before in order to keep the actual tenant out of the apartment.
Thank you. Thank you very much.
Thank you, Your Honors.